You thought you were pretty bad breaking into a cop's car, didn't you? That is some nerve. I mean, seriously, you're the second person I've had in 11 years that has had the nerve to do that. And Mr.
The judge comes out swinging, making it crystal clear that this isn't your everyday theft. Breaking into a police car isn't just illegal, it's practically asking for trouble. Her voice has that mix of disbelief and frustration that tells you she's seen a lot, but not this very often. What do you think? Reckless bravado or just plain stupidity?
Mr. Thomas was previously in court, entered pleas of guilty in cause number 24 DCCR 0389 to the third-degree felony offense of prohibited weapon. Cause number 24 DCCR 0390, also a third-degree felony of possession of a prohibited weapon. Cause number 24 DCCR 0391. Pled guilty to the state jail felony offense of theft of a firearm. Cause number 24 DCCR 0392, pled guilty to the lesser offense of indecency with a child by exposure, also a third-degree felony. There was no plea agreement. I have received and reviewed the pre-sentence report. Has everyone had an opportunity to review that report?
State has it.
In addition, there is also the largest packet I've ever received of jail incident reports in a case. Did everyone have an opportunity to review those?
Yes, I took an evening and
35 pages.
The rap sheet isn't just long, it's layered. Weapons, theft, and a disturbing indecency charge with no deal to soften the blow. And those 35 pages of misconduct. That's not a good look. In court, largest packet I've ever seen, is never followed by good news. If you were on the jury, how much would those jail incidents sway you?
Your Honor, this is a very young kid that in a very short period of time jumped or stepped off the cliff and got himself in a lot of trouble. I will represent to the court when I was encased by his family. One of my issues was the recovery of the weapons because they were law enforcement weapons. I will represent to the court that almost immediately, mysteriously, weapons ended up in my office in the front hallway and were returned to the sheriff's department. And I'd like the court to take notice that those weapons are off the street and back into
The defense is leaning hard on the young and dumb angle, trying to frame this as a rapid fall from grace. They even point out the weapons were returned, mysteriously appearing in the lawyer's office. But here's the thing. Returning the loot doesn't erase the crime. Would that matter to you, or is it too little, too late?
We go open because I do not have a recommendation. You can place him on probation for a period of 10 years and see what he does. These are third-degree felonies that you can do. At the very end, state jail does the theft of the firearm. You could put him in a state jail for a period of time and put him on probation for the other one. I would ask that if you are going to send him to the penitentiary, that maybe in reference to the sexual offense, that you do place him on probation, so that you can have some accountability for him once he got out for a period of time. That would give the court maybe whether or not he's learned his lesson. Now, as you peruse through the 35 pages of incident reports, and I'm not trying to be funny, because I've talked at length with Mr. Thomas about those, and he'd like to address the court on those. It is what it is, and that's not behavior of whether or not he would be able to follow the court's orders if he can't follow what's going on in jail for a period of time in reference to probation. I would ask that the court would ask Mr. Thomas.
Yeah, go ahead. You have something to say?
Well, you don't have to say that. I could just say it's just young, dumb, just being in jail at a young age and not really knowing that. I got write-ups.
Yeah, but once you get several write-ups, the whole point of growing up is to learn from your mistakes.
Yes, ma'am.
So if you keep getting write-ups, then you can't just say I'm young and dumb, so I keep getting write-ups. I don't disagree that you're young and dumb,
Yes, ma'am.
but this is ridiculous. Like, I mean, I know our jail cannot wait for you to get out.
This is where the I've changed defense starts to crumble. The judge isn't buying it, and she's got 35 pages of proof. If you're racking up disciplinary write-ups in jail, it's hard to argue you're ready for freedom. Do you think bad jail behavior should weigh as heavily as the original crime?
Yes, Your Honor, I'll be brief since I put everything, made the state's position clear in our sentencing memorandum. I'd like to briefly shift the focus from the write-ups to the underlying facts in this case, which I believe are
Stealing out of cop cars.
stealing from patrol vehicles, at least 2 patrol units, Your Honor. Detective Matt Dixon is here if you want to hear more details of the detective. But Your Honor, I think the audacity, the boldness to steal these weapons from a police car goes to show what exactly the nature of this defendant is and what we're dealing with here. And even more than that, Judge, it appears from the underlying facts that the defendant may be implicated in a series of other car burglaries. We've got a Glock switch that converted one of those weapons into a fully automatic weapon. He was conspiring with another juvenile, a 16-year-old, to steal the weapons, which a photograph is attached to my sentencing memorandum if you've seen it. This was nothing less than an arsenal that these kids amassed, Judge. I shudder to think what could have become of these weapons if they would end up in the hands of other criminals, if they could have been used against law enforcement, Your Honor. Long gone are the days where there's a low caliber Saturday night special that these kids use, you know, in some type of a crime. They are loaded for bear with fully automatic weapons. I'd ask the court to make an example out of this defendant. He benefits from not having a criminal history to speak of, but Your Honor, this is beyond the pale. I'd ask you to send him, do 2 things, a split sentence in this case. Sentence him to prison for what he's done, and then following that, a consecutive probation period so that we can continue to monitor him and supervise him.
This is where the stakes jump off the page. Fully automatic weapons, stolen from law enforcement, teamed up with another teen. The prosecutor isn't just asking for punishment. They want this case to send a message. Do harsh sentences, actually deter others, or just punish the one in front of the judge.
What are y'all doing? What are you doing with all these?
In Texas, a judge
Not shooting
can
people.
Sir?
Not shooting people.
Not shooting people yet. What are you shooting? Why would you have these? What are you getting these to shoot at? Just to be tough and say you have guns?
No.
That's all that's happening with these guns on the street, is y'all are shooting at each other, at other people, at houses, at cars, at whatever. There's no reason to have these kind of guns. These aren't hunting guns, right? You're not going to shoot a deer. Do you hunt?
I do.
Do you?
I have before, but
Have you?
Yes.
Which one of these is your hunting?
The judge dismantles the "I'm a hunter" excuse in seconds. None of these weapons are for deer, unless you're expecting the deer to shoot back. Her point is clear. These guns are meant for one thing, and it's not sport. If you were the judge, would you even entertain the hunting claim?
Here's what I'm going to do, because I agree with Mr. Coleman. I would like, at least in the indecency case, to get treatment and probation on that case so that we know you're not going to go make that type of bad decision again. But I'm not giving you probation on everything. You're going to you want to change your life and do better and not be young and dumb, you're going to have some time to figure that out. So in cause number 24, DCCR 0389, I'm going to find that you entered your plea of guilty freely and voluntarily, find sufficient evidence to find you guilty, and at this time find you guilty of possession of a prohibited weapon. Mr. Coleman actually asked me to sentence you to 5 years. I don't think that's enough. I'm going to sentence you in that case to 7 years in the institutional division of the Texas Department of Corrections. You'll receive credit on that sentence for any time you've been in custody, and part of the reason I made it lengthier is because you have been in custody so long, and a 5-year sentence really isn't going to amount to much. Cause number 24, DCCR 0390, also find sufficient evidence to find you guilty, and at this time find you guilty of possession of a prohibited weapon. Sentence you to a term of 7 years in the institutional division of the Texas Department of Corrections. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. In cause number 24, DCCR 0391, finds sufficient evidence to find you guilty, and at this time, finds you guilty of the state jail felony offense of theft of a firearm. Sentence you to a term of 2 years in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. Then in cause number 24, DCCR 0392, finds sufficient evidence to find you guilty. However, in that case, I'm going to defer all proceedings, place you on probation. No, that's the third. I'm going to find you guilty of that offense, sentence you to a term of 10 years in the institutional division, but I'm going to suspend that and place you on probation.
The hammer falls, and it's heavier than expected. The judge gives more than the state asked for, signaling she sees this as bigger than just another weapons case. It's a rare moment when the court decides even the prosecution was too lenient. Would you have gone lighter because of his age, or is this exactly what was needed?
Years.
Can I address the court on that? With the deferred, though, with the registration, it would, if he did comply after he got out, that he may have a chance instead of a conviction.
He's already got 3 convictions.
I
The fourth.
understand that, but a sexual kind of.
May I respond, Judge? That is a reduced plea to a reduced charge.
I agree. Waived your right to appeal. In these cases, I'm going to hand you those certifications. I'm also handing you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Burbank.
This is the legal equivalent of a final warning. A crystal clear reminder that one wrong step after release could put him right back in a cell. It's a narrow road ahead, and the judge makes sure he knows it.